Good morning, everyone. Thank you for attending today. So today's webinar is covering a very sensitive and emotionally charged topic, as you guys would realize. So at the outset, I would just like to mention that we would not be able to answer specific situations and questions of a specific nature, obviously due to the limitations that we have. At the end of this presentation, we will be able to share the details of an organization that you may approach for assistance. So please look out for that as well. So let's just begin with the overview of today's webinar. So we're going to cover what is sexual harassment and sexual assault, the impact of sexual harassment and the general remedies. We're also going to cover sexual harassment in schools, which is an important topic in today's times, and of course, sexual harassment in the workplace, which is also becoming prevalent. So let's just go into what is sexual harassment. So certain discriminatory and unwanted actions by a perpetrator, which include unwelcome sexual advances, requests for sexual favors, verbal or physical harassment of a sexual nature, is what falls within sexual harassment. But of course, this has to be against a victim and which causes some form of harm to the victim. You must also remember that sexual harassment is not always specifically about sexual behavior against a specific individual. It is also, can include negative comments about women as a group or a group of individuals in terms of sexual nature. So that is sexual harassment. And, we often ask the next question of what is sexual assault? Sexual assault is defined in legislation and it makes it a criminal offense. So in terms of the Sexual Offences and Related Matters Amendment Act, there are certain defined actions or conduct which we could deem as falling within sexual assault. So it's where someone sexually violates another without their consent or inspires the belief that they will be sexually violated. So what is sexual violation? It refers to the physical actions, for example, unwanted or inappropriate touching of a sexual nature. Now, it is important to understand the fact that it says unwanted and inappropriate touching of a sexual nature. The unwanted becomes rather important as this is a test between sexual assault and normal touching. There are obviously other types of sexual offenses which are listed in the Act as well, and some of them would be rape, sexual exploitation, and sexual grooming of children. So sexual grooming of children is a very big topic that comes up over and over, on the news and from everywhere else. So it is important for us to also be aware that this is in fact an offense itself. So in terms of sexual harassment and assault, there is obviously a difference. What may be deemed as sexual harassment is not necessarily an assault. So for example, a work colleague makes sexual advances to you through inappropriate comments. That may not be governed as an assault. It is harassment of a sexual nature. And this type of conduct would naturally fall against, your employment equity rules and discrimination at work and go against policies and procedures at work, including, the general norm at work as well. So just remember that the difference is that while sexual assault is a criminal offense and falls within the Act, sexual harassment is a far broader term. And it is important to understand that sexual harassment is governed by other principles, whereas sexual assault is governed by your law. And there are instances where you could be a victim of both in certain instances. So I'm going to hand over to Jellica for a moment and just ask her. So Jellica, from your perspective, what does sexual harassment, how does it affect victims?
Thank you, Dee, and good morning to everyone. Sexual harassment, sometimes it may be a minor incident and sometimes it may be of a more serious nature. However, the effect that it does have on the victim can be considerable. Sometimes the victim will experience psychological effects. They may experience depression, anxiety, mood swings, and sometimes the effect may be physical. They may suffer from insomnia, they may have weight loss, weight gain. Also, they may experience sexual dysfunction. Um, Sometimes victims may also experience post-traumatic stress. In the work environment, there are other effects that it could have, job-related. It could result in decreased morale of employees. Also, the relationship between employees, whether it's the victim and the perpetrator or other employees, it may create a hostile work environment. And with regards to the higher education setting, maybe a university, student victims of sexual harassment will often may feel pressured to drop a class, even may want to change their degree. Overall, despite what setting the harassment occurs in, the effect on the victim is considerable and they may experience one or more of the effects that I've just mentioned.
Thanks, Jellica. And what general remedies would be available to victims in these types of circumstances?
Okay, a victim may pursue the criminal route and lay criminal charges. And if the perpetrator is found guilty, they may be subjected to a fine or imprisonment, and they may also be listed on the register of sex offenders. If the victim there wants to pursue the civil route, they may receive compensation for damages from the perpetrator. The victim can also get an interdict, which will stop the perpetrator from the continuation of the sexual harassment. And obviously, it depends on what type of environment the sexual harassment took place in. There may also be internal remedies available to the victim. For example, in a workplace, the victim can approach HR and there'll be internal remedies, or if it's at school, a school governing body. But despite what setting it occurs in, because sexual harassment can take place anywhere, for example, a religious organization, at a church, a gym, a school, a university, they may pursue the civil and or the criminal routes, even though they use the internal remedies. So they may pursue all these remedies if they wish to do so. Lee, maybe you can now touch on the important, quite an important issue, sexual harassment occurring in schools.
Thanks, Jellica. So, more often than not, we're starting to read articles and newspaper headlines about harassment happening at schools of a sexual nature. And it's becoming quite a major issue within South Africa. So, firstly, an employer, it's just important to understand that an employer is obliged to actually deal with a case of sexual harassment or sexual assault. Very important. So in terms of schools, we must remember that when we hand a child over to an educator or to a school to take care of our kids, there is a principle which is derived, which is called the in loco parentis principle, where basically we say that the parents are entrust the educator with the custody and control over the kids while at school. This means that the educator acts in the place of the parents, and therefore there's a duty on them to obviously protect the learners and our kids that are in school. So firstly, we must remember there is the equality amongst learners, which is in terms of the Constitution, and it's regulated in terms of Section 9 of the Constitution in actual fact, due to the fact that we have learners who have the right to schooling, the right to not be unfairly discriminated against, the right to protection of dignity and integrity, the right to freedom, the right to privacy, and the right to a safe environment. Therefore, our kids are protected overall in terms of the learning environment to make sure that whatever actions happen in a school fall within these rights. We also have the Children's Act, which creates a legal duty on educators, where any form of maltreatment or sexual misconduct, etc., against children, they are obliged to report it to the police or the welfare, which in itself obviously should create the presumption that there should be a prevention of the teachers themselves or the educators actually harassing school kids. So we must report obviously these maltreatment or abuse. We can report it to the social welfare or to the SAPS. We don't necessarily need to follow that route of the social welfare or SAPS. We can go directly to the SAPS itself. If, of course, there is in fact sexual harassment in schools, which is what happens if an educator sexually harasses the learner. So the South African Schools Act, firstly, creates a code of conduct which is aimed at discipline and general codes of conduct by educators and the school itself in the school environment, and ensures a certain type of discipline. The Employment of Educators Act, or the Educators Act itself, also creates the presumptions where disciplinary action must be taken against an educator. So it's not something where you can choose to do it, it is must. Even where there was mutual consent between the learner and the teacher, well, obviously age plays a factor, and that is also protected in terms of General Amendment Act, the Sexual Offences Act. The educator found guilty must be dismissed. Educator's name will also be removed from the South African Council for Educators based on this allegation and obviously the conduct. So the learner should first report it to a parent or a teacher in the school, or even the school governing body. That's where they can report it. Nothing prevents them from proceeding to lay criminal charges against the perpetrator. And then, of course, there are other civil remedies also available to the victim, and perhaps the victim's family, depending on the circumstances itself. So, Jerica, if you could perhaps just assist. I mean, we've covered obviously schools, we've spoken in general about gyms, etc., and other institutions. Could you perhaps maybe mention to us what would happen at work, as this is also quite a big topic?
Okay, Lee, before we go into that, can we quickly do another poll question?
Yeah, sure.
Okay. So, protecting children from sexual abuse. Do you think that there's a duty on anyone to report sexual abuse of children? Is your answer yes or no, or are you not sure? Okay, everyone is actually correct. Yes, there is a duty on anyone. If you know of any child who is being sexually abused, you have a duty to report such abuse. So that is the correct answer. Thank you for everyone for participating on that poll question.
So sorry, Jerica, I just want to mention as well that we must just remember that when we discover abuse of kids, it doesn't have to be your children or someone you're related to. It can be a stranger or anyone else that you suspect that is happening. There is in fact a duty on you to please report it. In terms of the Children's Act, in terms of legislation, and it's just the right thing to do.
Thanks, Steve. Okay, now we can go into sexual harassment in the workplace. So our courts have actually described sexual harassment that occurs in the workplace as one of the most heinous forms of misconduct that plagues the workplace. In terms of the Employment Equity Act, sexual harassment in the workplace is a form of unfair discrimination. Now, a sexual harassment in the workplace doesn't only occur between an employee and an employer. Generally, sexual harassment in a workplace can occur between any relationship around that work environment. So it could be between an employee and a client, or an employer and a supplier, a manager and a potential job applicant, basically any relationship that occurs in the workplace. And the forms of sexual harassment, once again, as we mentioned, it could be physical contact, such as touching, to sexual assaults, or it could be verbal or non-verbal contact. So it could be inappropriate sexual jokes, or maybe exposing someone to indecent pictures. Lee, now that I've mentioned that sexual harassment can occur in the workplace, can you maybe take us through the specific type of sexual harassments that do occur in the workplace?
So we've got different types of harassment that can occur. So we've got favoritism, we've got quid pro quo, and we've got virtual types of harassment. So sexual favoritism, of course, is when a person in authority favors those who respond to his or her sexual advances. And of course, it's coupled usually with the fact that a person is victimized where the employee fails to submit to these advances. And of course, the person is then obviously offered or promoted or given some kind of, favoritism within the workplace as well. And obviously, the negative obviously happens with sexual favoritism, that if you don't give in, you then suffer the consequences of not being, moved forward or advancement within the workplace. Then we've also got quid pro quo harassment, which is where a person influences or tries to influence the employment circumstances itself, where basically, you give me something, I give you something, which usually creates increases or promotions and stuff like that, and kind of forcing or attempting to force the employer to surrender to these sexual advances. And then, of course, in the more prevalent type of harassment would be coming out in the new working environment, which is virtual. So here, we all are working virtually. We're communicating via WhatsApp and multimedia and just the various platforms, social media platforms. So this would include inappropriate dress code during online meetings, online stalking, forcing employees to attend video calls way after working hours for different purposes than actual work, making personal remarks on a colleague's social media status or on their social media pages, sending inappropriate multimedia texts or videos, etc. And we must not forget that even the sending of inappropriate emojis or messages online can also constitute this as well. So, Jerika, if you can just maybe, you've touched upon the work situation. Could you perhaps tell us what factors would be taken into account when dealing with sexual harassment at work?
Okay. So the following factors will be taken into account when dealing or considering issues of sexual harassment. The first one is the harassment must be on a prohibited ground of either sex, gender, and/or sexual orientation. The sexual conduct must be unwelcomed. The nature and the extent of the sexual conduct will also be considered. What type of the nature, how serious it was, whether it was just touching, whether it was full-on sexual assaults, and also the impact that the sexual conduct has actually had on the victim. Okay, those are the factors that will be taken into account when considering a sexual harassment. Lee, can you just tell us, are there any specific obligations on employees with regards to sexual harassment or when they receive a complaint of sexual harassment?
Yep. So, with employers, there are obligations. So some of these obligations arise from the Employment Equity Act, but it basically requires that there should be a policy in place and there should be an implemented policy so that people are aware of the processes and what would constitute this. If they receive any form of query or grievance or anything of that nature, they should be conducting an investigation. And a company generally should be taking steps to eliminate sexual harassment in the workplace. Therefore, if there's an environment or conduct that is being displayed, they should be taking steps to deal with that. And then there should be steps taken to address these complaints of sexual harassment. And of course, inform complainants of the available procedures that are in place. So staff should be well aware of what are the policies in place. It should be housed in a place where people have access to it, and that they are able to access the exact procedures and processes that are involved. So it is very, very important that they ensure that they follow procedure, that employees are protected in the form that they are aware of who to complain to, how to complain, where to complain, and that they're obviously not harassed or victimized for complaining as well. Therefore, there should be some form of confidentiality as well when dealing with these types of matters, as it's obviously of a very sensitive nature. Jerika, if you could perhaps also advise, what must an employer do upon receiving the complaint of sexual harassment? Oh, sorry, I've covered that. Maybe if you could tell us what the procedure would be.
Okay, thanks, Lee. Basically, there are two procedures that could be followed. Firstly, we have informal procedure. So the complainant will report the incident, and what happens, a discussion can take place, explaining to the perpetrator that, the conduct is actually, it's unwelcomed and it does amount to sexual harassment. But here with the informal procedure, the complainant can also remain anonymous. So he or she may not want to reveal their identity, and they may have confided in maybe a manager or an HR representative. And this person can actually have a sit down with the perpetrator and say, your conduct is not welcomed, and it does amount to sexual harassment. So once again, with the informal procedure, it's either you can remain anonymous, or if you want to, you can reveal your identity, in which case you will have a sit down with the perpetrator, telling him his conduct is unwelcomed. And if you want to remain anonymous, someone else will do it on your behalf. So it's basically just a discussion. Whereas we have the formal approach. Now, the formal approach is a bit more stricter, and the consequences or the sanctions imposed on the perpetrator may be a bit more severe. So the incident, once again, it is reported, but there are also certain time frames and procedures that will be applicable, and a disciplinary hearing may also be held. Evidence will be given by the perpetrator and the victim, and here the chairperson will give the final outcome. So the final outcome could be as severe as dismissal. And here, either the victim or the perpetrator, if they are not happy with the outcome, they still have the opportunity to approach the CCMA. What's important to note is that a complainant, I think you've mentioned this, Lee, a complainant must be able to report the incident without the fear of being victimized or retaliated against.
Thanks, Jerry. And so we're discussing a lot about the procedures by the company. What are the possible consequences to a perpetrator in an instance like this? Okay,
so the possible consequences. So not every instance leads to dismissal. Firstly, the type or the nature of the sexual harassment will be considered. Sometimes it may be minor, maybe just a simple comment or joke, and a final written warning may be sufficient in this instance. Sometimes it may be more severe, in which case the perpetrator may be transferred to another department or a different position, just to prevent the creation of a hostile work environment. And obviously, there is the most severest sanction, which is dismissal. Yeah, so dismissal being the most severe. So it will just depend on the nature of the sexual harassment. That will just determine how the employer or how the chairperson actually makes their decision. So once again, we're just going to say the employer, so they can report the matter to the Human Resources Department, but they can also still lay the criminal charge and the civil charge. So it's not either or. The civil remedies and the criminal remedies will still be available to the victim despite there being internal action being taken by the employer. I think that's important to remember. They still have the option to pursue the civil and the criminal charges if they wish to do so. Okay, so
Thanks, Jellica. And you mentioned that yeah. Sorry, Jellica, I'm not sure if you can hear me, but if you've mentioned the civil remedies and the fact that we can lay criminal charges. So how do the courts actually view sexual harassment?
Okay, I think I mentioned that quote in the beginning of the webinar where the courts have described sexual harassment as one of the most heinous forms of or actions that actually plagues the workplace. And our courts have taken quite a strict approach and are often not hesitant to impose the severest sanction being dismissal. But I'm just going to mention one of the most recent cases that I've looked at. I'll just go through the facts briefly. So 2 employees were alone in an elevator, and the victim complimented the perpetrator on his beard. And he saw this as an invitation to kiss and touch her and make very inappropriate comments and ask her inappropriate questions. She reported the matter and he was ultimately dismissed. But when this matter came before court, what the court had to say is quite significant. The court said that just one instance of harassment is sufficient. So I think it's very important to remember that the harassment does not have to be continuous texts, continuous chats. One incident of sexual harassment is enough to be considered serious. What the court also said is that sometimes you may be in a position where it's difficult for you to object, but yet you are uncomfortable. So the surrounding circumstances will be considered. So a failure to object to the unwelcomed conduct is not consent. And the court also went on, as I mentioned, to say the seriousness of sexual harassment is considered. And in this case, they said that dismissal was the appropriate sanction. And also important to mention that when they were making their decision, they very closely looked at the employer's policy as well, which actually reiterates what you said, that it's important for employees to have a sexual harassment policy so they know how to deal with it, and also so that their employees are aware of what constitutes sexual harassment and what sanctions may be imposed and how it is actually dealt with in the workplace. Hey, Lee, if there's anything else you want to add before I hand over to George, he's just going to speak a little bit about the Tears Foundation.
Oh, thank you, Jellica. So I think you've covered it in general, and I think it's important for us to just understand the fact that it doesn't have to be repeated incidents, nor does it have to be, that you didn't say no. Mere fact that you didn't object and mere fact that it happened is severe enough for the matter to proceed. I think that is an important point for people to realize. So thank you very much, Jellica. George.
Yes, and thanks, Lee and Jellica, for the information. Before we get over to the questions that were asked and questions we want to answer as well, separately, I just want to mention, and as you said, and it's clear from what you discussed that, there's all these various instances and examples of sexual assault or sexual harassment, and it doesn't always have to just occur at one place. For example, you guys discussed, in the schools and in the workplace, but whatever principles apply there, the same principles can almost be applied anywhere else. I mean, if you are, for example, in the gym or at church or at university, the same basic principles applies. And what Jellica mentioned in the beginning about the general remedies, you have either criminal charges that you can lay or there's civil remedies. The same remedies are also available in those instances. So for the attendees, I just want to mention that although we just focused on schools and the workplace, it doesn't mean that you can't take whatever you learn from this webinar and also now apply it in another circumstance. And with that in mind, and Lee mentioned that you can report it to social welfare or the SAPS, or in the workplace you can report it to your human resource department and so on. But there are various other organizations, and like, for example, non-profit organizations that also help and assist victims of sexual harassment or sexual abuse to report this matter, to deal with the trauma they may suffer as well. Just to give some advice, community advice officers are also available. And one of our collaborators that we have been worked with in the past is the Tears Foundation. And for those who want to jot down the contact details, you are more than welcome to do that. And I have also presented a few seminars with the Tears Foundation about this topic as well. So they do help and assist victims and do that. And for those of you who are members of LegalWise, you can also contact the nearest branch and get advice in that instance. And also, get involved in your community and see what other organizations are there in your community you can contact, or if you have any suspicions or any concerns, reach out. Lee, you mentioned this is quite a serious matter as well. And unfortunately, sometimes it is a matter or an instance that gets swept under the carpet in some instances, and we need to get to a habit where we reach out about this aspect. And there are ways, Jellica mentioned, you can stay anonymous if you want to. So there are ways. You don't have to always fear of now everybody's going to know what's happening. I know it's a sensitive matter as well. And just to link this back to the heading of this webinar is, we saw that it does happen, and it is a serious matter, and everybody do have rights about this instance. And it's important, and I've always been a big front runner of, you need to know about this matter so that you know how to enforce your rights. A lot of people out there don't always know what their rights are. So with that in mind, I'm going to we have a few questions, lead into questions, and Lee and Jellica, you can then answer that. So the first questions we have is from Satiwe. He says, does the SH policy only cater for conduct within the workplace, or can this be extended to other areas? Example, advances by a manager on a holiday, for example. So I think basically what we can take from that is it only in, let's say, for example, if it's in the workplace, does it only relate to the office space, the work environment, or can it go beyond that as well?
So if I could just jump in quickly. So the sexual harassment policy at work would apply to any work scenario. So even if you are outside of the office premises, but attending a work function, for example, which is deemed as part of your duties or your processes, then the policy would apply to that as well. The only time that a policy would not apply is if you're obviously not conducting anything work-related at the time. But if you're in the same setting, which is deemed as work-related, for example, a seminar or a gathering of employees at the company's request, then yes, it would apply.
Thanks, Lee. And then another question, well, there's two questions and they sort of link to each other. Who does the audit in the workplace? Who's doing I'm thinking as well as who's doing the investigation and the audit in respect of the sexual harassment claim? I don't know which one of you want to address that one.
So I can jump in a little bit here. So normally it would depend on what the policy would be at the specific and procedure within the specific environment. But generally it would obviously be conducted by human resources or human capital business partner. And then, of course, if it goes into some form of formal hearing, it would then be conducted, the hearing itself would be conducted by a chairperson who is supposed to be impartial. But the actual conduct of the investigation should be done by a well, as I said, it would depend on the policy and procedures of the company, but generally that does happen where it's done by a human resource or a manager who is not involved in the actual process itself.
Mm. And just to follow up on that as well, what is the instance then, if you can give some guidance, if there's no HR department? It's, for example, a non-profit organization or a smaller firm or employment or a company that does not have the a big HR department, human resources department dealing with this. Any advice in that regard?
So normally what smaller companies do is they do outsource to places like, I'm going to use a name like, for example, LaborNet, who conduct some of their HR functions for them and disciplinary. Obviously, it is a bit difficult when you're in a small company and there's no HR and it's, like 5 employees, for example. But generally, it's you can actually, if you report it and the outcome is not in your favor or you're not happy with the process that was followed at the work scenario, you then have the right to report it to the CCMA in terms of an unfair labor practice, or alternatively, you can also report it to the SAPS depending on the type of conduct.
Thanks, Lee. Anything you want to add, maybe, Jelika?
No,
Before we
no,
get
George.
cool. The next question is on Tandu. What is the effect of listing offenders on the sexual offenders list? Is it applied in the same manner as with a criminal record, in that it appears whenever an individual is being vetted for either education, employment, or financial aid purposes? I'm not sure if anyone of you
can
want
assist
to...
on this one, Lee. I know some of the effects like of being listed on the registers. You aren't allowed to work in certain sectors, like with children or in an area that's close to children. But I don't know if you can advise, does it pop up like when you're doing a check on someone as a criminal record would?
So if I understand correctly, normally what would happen is when human capital does criminal checks, it would be dependent obviously on the type of environment as well that they're applying for. So from what I understand is you would normally obtain the services of an external company that would do these checks for you. And then you would normally specify the type of check that you require. So for example, in a school environment or dealing with minors, you would normally ask them to check, is there any convictions or sexual offenses and stuff. But when checking a person's criminal record, naturally you would pick up from that there was such an allegation, that there is a criminal offense.
And while we are on the topic of sexual offenders, the list, there's a question here. Are you only listed on the sexual offenders list if you've been convicted of a sexual offense? I don't know if you perhaps have the answer to that one.
I must be honest, I don't know that the specifics of the registration, but I do know that normally you would be listed only if you have been found guilty of an offense. Generally, it would be unfair for anyone to list you if you were just accused of something. So generally, it is you being convicted. However, I don't know the specifics of the actual listing.
Thanks, Lee. What we can do is we can just get clarity and then just maybe when you send out the link also get that question through. And then here's a question from Charlene, and I'll address this one. She asked, why must the referral to the CCMA be done in 6 months and not in 30 and or 90 days? So Charlene, with that instance, as Jelika mentioned, the Employment Equity Act does list sexual harassment as a form of unfair discrimination. And under the CCMA rules, for unfair discrimination matters, you have up to 6 months to report the matter. 30 days will be for unfair dismissal and 90 days will be for unfair labor practice. So, however, and I think also for me, from my point of view, is the longer the period is, it helps a little bit because, with this sensitive matters, sometimes it does happen that, the victim might not want to report it or keep it quiet for a little bit. So having that little bit time of the longer time might help with that instance as well. But again, to do it as soon as possible. You don't, just because you have up to 6 months or with the others 30 or 90 days, don't wait until day 29 or, the last day and then you think you have to do it. As soon as possible to get that sorted. So I hope that answers your question, Charlene. Just another question here from Tandu. Can people close, for example, neighbors, family, friends to sexual victims be criminally charged as accomplices in the event that they fail to report the sexual assault incident which they may have either witnessed or suspected.
Well, I don't think in all instances because they merely knew, but let's say, for instance, if a mother is aware that her child is being sexually abused by maybe an uncle who stays with them, then that would be different from maybe a neighbor who suspects that the child is being abused. I think the circumstances and the relatively the closeness of the relationships will have to be considered. I don't know if Lee and George want to add anything to that.
No, I agree with that. So I think it would be very dependent on circumstances and how much obviously the person does know. You know, the mere suspicion or thinking that it may have happened is not enough. But obviously, if you have intimate details of what's happening, you may have breached the duty to report and could be charged.
Correct.
But yeah, it's a little difficult to give anything specific, but it would depend on circumstances.
Yes, and just to add, so the word accomplices there is also of importance because, you know, with accomplice, usually it means that there's some other form of elements that must be applicable as well. So when we look at, like we said earlier on, there's a legal duty on all of us to report sexual abuse or maltreatment of children. And when you do not do that, then you will be guilty, not necessarily for being an accomplice, but you will be guilty under that piece of legislation where you fail to report the sexual offense, for example. Another question from Samu Kilesiwe. I see your hand is raised as well. Unfortunately, we are not able to, the format of this webinar is not that so that we can have you join us, but I'm assuming that this is your question you wanted to ask. What is the status of the sexual offences registry taking into consideration of repeat offenders? Lee, maybe you had something to say previously. Maybe you want to take this one?
Yeah, so normally, look, it's a little difficult because a person's obviously listed. You can't list them twice because it would obviously not make sense. Usually, obviously, if it's a repeat person who has been convicted a second time, the person more likely, depending on the circumstances, could possibly face jail time. So the courts would actually impose stricter fines or, how could I put it, imprisonment, etc. I can't completely tell you how it affects the registry, but my assumption would be that the person's already listed and that listing would probably just include anything further together with an extension of time if there's an expiry of time that the person's listed.
Thank you, Lee. And then just one more question that I have here is, what if the victim's claims of being sexually harassed were false? Will that impact it in any way? Or, you know, should we not even think of it and always just assume that whatever complaint has been raised will be true? How does the law deal with that?
Well, I know with company policies, I mean, if I falsely accuse of someone of sexually harassing me and it's completely baseless, disciplinary action actually can be taken against me for falsifying, making false accusations. It's just as serious. I think we must not take away from that. It's just as serious. I mean, laying false accusations against someone could result in disciplinary action taken against them.
Yes, I agree, Jelika. And again, it's that whole old saying of crying wolf as well. So yeah, so try and be honest at all times as well. One more question from Brandford. Can anyone be accused of harassment due to their gender? For example, men who are only available for heavy lifting, or the fact that they are just men. Is this considered sexual harassment?
I think it would be more gender inequality. Gender inequality would basically be where you're highlighting differences in terms of gender between parties. Sexual harassment, of course, and sexual assault is more of a invasive process, which you would more look at in terms of, you know, it's I don't know, George, if you can just help me here. I'm trying, the words are on the tip of my tongue, but it's just not coming. So it is a fine line, but the reality one is where you are picking on gender and you are trying to basically draw differences between male and female or between males and between females, and the other one is based on purely sex.
Yeah, I think we mentioned earlier, sexual harassment, it is sexual in nature. There must be a form of unwelcomed conduct that is kind of sexual in nature. And here with our example, men who are only available for heavy lifting, there's not sexual conduct, of a sexual nature. It's basically, there's a difference drawn because of gender. So it's not so much of a sexual nature, actually.
However, I think that, it's more discrimination as well. And as Lee mentioned, and I think in this instance, it's not to just exclude, not just to say that just because Jellica's a female, she won't be able to do any of the heavy lifting. And we're not even going to consider her. So let's say, for example, she wants to apply for a job. We're not even going to consider her at all. So I think it's that minor details that must also be taken into account as to try and not just exclude everybody, but keep it in mind in the application process or in the necessary circumstances as well. Another question, how are different cultures or world views or religions taken into consideration? What is sexually offensive to me might not be offensive to someone else. Thanks, Helen. That is actually a valid point. I'm not sure, Lee, Jellica, if you want to say something on that regard.
I think I just want to start off by saying, I think this is one of the instances that highlights why it's so important for employers to have a sexual harassment policy. So despite me being from a different cultural background to George, what it says in the policy will set out what is sexual harassment in some cases. And if I feel someone's conduct to me, obviously it's my view. If I feel offended, it's the unwelcomed conduct which makes me uncomfortable. It will be offensive to me. And obviously this may also be taken into consideration when dealing with the issue in the formal procedure, the informal. Was it a minor offense? Okay, this person didn't know he was actually making me uncomfortable. We can let him go with a warning. I think that's one of the ways that the policy will actually kind of regulate that situation. I don't know if George and Lee want to add anything to that.
I think it's just important to understand that when looking at this in the absence of any other information, we're obviously going to look at what would a reasonable person in that circumstance feel under those circumstances as well. So for example, you got to take the circumstance into consideration and the conduct, and in the absence of any other information, then look at what would a reasonable person in that circumstance feel.